Okay. I think we're ready.
Good afternoon, everyone, and welcome. My name is Rebecca Tepper. I'm the Secretary of the Executive. Okay, yeah. I am the Secretary of the Executive Office of Energy and Environmental Affairs and the Chair of the Energy Facilities Siting Board. Before we get started, I'll ask the Siting Director to provide the instructions on using the interpretation services being provided today.
We are providing interpretation services for this meeting in Spanish, Portuguese, and Cape Verdean Creole, as well as English. Whether you are here or on Zoom, you will have access to interpretation services being provided. If you are here in the room, you can access interpretation by using a receiver and headphone set. If you need a receiver and headphones and do not have them, please go to the table here at the side, and Mr. Mengesha can help you with your needs for that, and you can adjust the volume as needed. Channel 1 is Spanish, Channel 2 is Portuguese, Channel 3, Cape Verdean Creole. For those on Zoom, in just a moment, we will activate the interpretation. After I do that, at the bottom of your screen, you will see a globe icon button that says Interpretation. Click the globe and then make your language selection. For example, to hear in Spanish, select Spanish. After the interpreters read these instructions, first in Spanish, then Portuguese, then Cape Verdean Creole, I will activate the channels so users can select their language. Again, please make your language selection after the globe icon appears. Let me just introduce our interpreters first before they begin. We have today interpreting in Spanish, Jose Jimenez, Jackie McVicker, Bella Ronchi is interpreting in Portuguese, Fermo Pompo, also Portuguese, Zenilda Cruz in Cape Verdean Creole, and Carlos Brito, Cape Verdean Creole. So thank you, interpreters. Once they complete their instructions, we will not be seeing them on screen, so wave goodbye. Thank you. Please do the interpretation of the instructions.
Estamos proporcionando servicios de interpretación para esta reunión en español, portugués y creol cabo verdiano, además de inglés. Y sea que están acá en persona o a través de Zoom, tendrán acceso a los servicios de interpretación proporcionados hoy. Si están aquí en la sala, pueden acceder a la interpretación utilizando un receptor y un conjunto de auriculares. Se necesita un receptor y auriculares y no los tienen, por favor, diríjanse a la mesa al costado de la sala para recibir asistencia. El español está en el canal 1 del receptor y el portugués en el canal 2 y el criol caboverdiano en el canal 3. Pueden ajustar el volumen según sea necesario. Para aquellos en Zoom, un momento activaremos la interpretación en Zoom. Después de hacerlo, en la pantalla inferior de su pantalla verán un icono de globo que dice interpretación. Hagan clic en el globo y luego seleccionen su idioma. Por ejemplo, para escuchar interpretación en español, por favor seleccionen español. Después de que los intérpretes se lean las instrucciones en español, portugués o criol cabreriano, activarse las canales de Zoom para que los usuarios puedan seleccionar su idioma. Nuevamente, por favor, hagan su selección de idioma después de que aparezca el icono de globo.
Estamos oferecendo serviços de interpretação para reunião em espanhol, português, crioulo cabo-verdiano, além de inglês. Quer esteja aqui ou no Zoom, você terá acesso aos serviços de interpretação oferecidos hoje. Se estiver aqui presente na sala, você poderá acessar a interpretação usando receptor e fone de ouvido. Se precisar de um receptor e fones de ouvido e não estiver ainda, dirija-se à mesa ao lado da sala para obter ajuda. O idioma espanhol será disponibilizado via canal 1, enquanto o idioma português via canal 2 e o crioulo cabo-verdiano via canal 3. Você poderá ajustar o volume conforme necessário. Para aqueles que estiverem se conectando via Zoom. Daqui a pouco ativaremos a interpretação via Zoom. Depois que feito isso, a parte inferior da sua tela aparecerá um botão com o ícone de um globo que diz interpretação. Clique no globo e em seguida faça a seleção do idioma. Por exemplo, para ver a interpretação em espanhol, selecione espanhol. Para ouvir em português, selecione português. Depois que os intérpretes lerem essas instruções em espanhol, português e crioulo cabo-verdiano, ativarei os canais no Zoom para que os usuários possam selecionar seu idioma. Novamente, faça a sua seleção de idioma depois que o ícone do globo aparecer. Obrigado.
Boa tarde, tudo alguém nos até providencia serviços de interpretação para a reunião ali na espanhol, português e crioulo de cabo-verdiano e também na inglês. Se você lê via Zoom, você pode ter acesso para interpretação que também ser providenciado hoje. Se você lê na nossa sala fisicamente, você pode acessar a interpretação, então utiliza aquele recebedor com um set, com um conjunto de auscultador. Se você quer ter aquele conjunto de auscultador, você pode ir para aquela sala ali ao lado para receber assistências, pode dar um auscultador. Portanto, se você quer escuta espanhol, você pode selecionar canal 1. Se você quer escuta português, você seleciona canal 2. Se você quer escuta na crioulo de Cabo Verde, você seleciona canal 3. Portanto, para que alguém que está na reunião via Zoom, dentro de momentos, não também ativa que esse canal de interpretação na Zoom. Depois que faz aquilo lá, na fundo de tela, você consegue jogar um ícone globo que está falando interpretation, ou seja, interpretação, e você clica naquele globo e depois faz seleção de língua de preferência. Por exemplo, se você quer escuta reunião na cabo-verdiano, você seleciona Cape Verdean Creole. Depois que tudo, intérpretes cabem e lê as instruções na espanhol, na português e na cabo-verdiano, onde também ativa esse canal de Zoom, que é para tudo que o utilizador pode selecionar essas línguas. Novamente, por favor, nós seleciona nossa língua de preferência depois que aquele ícone globo aparece. Obrigada, thank you.
Muchas gracias. Muchas gracias. Obrigado. Wayne, could you start the interpretation, please? We're on? Good, okay. All right, we should have the interpreters on their proper channels. Just confirm that, Mr. Wong. Interpreters are on the channels? Yes, okay. One final language instruction before we begin the substantive part. If you are here, or I'm sorry, if you're on Zoom and you are interested in using the closed captions and translation features of closed captions, you can activate that by going to the bottom of the screen where you see my icon hovering over Show Captions. You can select the, yes, you can select your language here by my speaking language, and there are many options here if you'd like to have closed captions in other languages. And with that, I think we are now finished with our language and interpretation instructions.
All right, welcome everyone again. This is a hybrid meeting of the Energy Facilities Siting Board taking place at the offices of the Department of Public Utilities, 1 South Station, Boston, and on Zoom. This hybrid meeting format is intended to allow everyone to see and hear all speakers, whether here or on Zoom. With me today are the other members of the Siting Board, whom I will introduce in a moment. The meeting today relates to docket number EFSB 22-04, DPU 22-67, and 22-68, known as the SouthCoast Wind Energy LLC project. In this project, SouthCoast Wind is proposing to construct and operate offshore and onshore cables and a new converter station that would connect a proposed offshore wind farm 30 miles south of Martha's Vineyard to the existing National Grid Brayton Point substation, and from there to the New England power grid. The purpose of today's meeting is to listen to comments, deliberate, and vote on whether to approve with conditions, or reject the tentative decision issued by the Siting Board staff on September 20th. The Siting Board provided notice of today's meeting to the following entities: the service list for this proceeding, state legislative members from the project area, and community-based organizations in the project area. The notice was also posted on the Siting Board's website and the company's website. In addition, notice of this board meeting was provided under the open meeting law. The notice and the tentative decision were provided in English, Spanish, and Portuguese. So with me here today is Jamie Van Nostrand, Chair of the Department of Public Utilities, Stacy Rubin, Commissioner of the Department of Public Utilities, Bonnie Heipel, Commissioner of the Department of Environmental Protection. John Costco is online with us. He's the General Counsel and the designee of Secretary Howe for the Executive Office of the Economic Development. Ben Hobbs, the Deputy General Counsel of the Department of Energy Resources and designee for Commissioner Mahoney, and Joe Benefigli, I'm sorry. Joe, who's one of the public members, and Greg Watson, who's online, who is also a public member. In addition, Andy Green, Director of the Siding Board, is here and will be serving as our host. Before we begin the substance of the meeting, I'll provide some important information about how we will be conducting this meeting. The Siding Board is conducting today's meeting both in person and remotely using Zoom. This meeting is being recorded and will be available on the Siding Board's YouTube channel. For our remote attendees, if you're having any difficulties with Zoom, please call or text 857-200-0065 for assistance. I want to note some procedures we'll be following. All board members must be audible to each other and the audience. If there are significant technical difficulties, I'll stop the meeting to resolve the issue. A stenographer is present today to transcribe everything said to make an official record of the proceeding. Everyone should speak slowly and clearly and allow a speaker to finish before you begin speaking. These procedures will help ensure an accurate transcript. The sequence of the board meeting today is as follows. We will listen to comments from public officials. Then the Siding Board's presiding officer will make a presentation, followed by comments from SouthCoast Wind Energy and the parties in the proceeding. And finally, we will listen to public comment. The board will then begin its deliberations on the tentative decision, consider possible amendments to the tentative decision, and finally vote on the tentative decision. We will take a 10-minute break at 2:30 and another at 3:45 as needed. Commenters should have pre-registered as described in the notice. If you have not pre-registered, we will do our best to accommodate you within the time available. All right, we're now ready to begin the substantive portion of this hearing. There is one item on the agenda this afternoon, consideration of the tentative decision for EFSB 22-04, DPU 22-67, and 22-68, known as the SouthCoast Wind Energy LLC project. Are there any elected officials here today? Any online?
If there are any public officials who'd like to speak, please use the raise hand feature, which is the icon at the bottom of your screen if you're on Zoom. I do not see any, Secretary Tepper.
Okay. Before we go to the presiding officer, can we have the attorneys do notice of appearance?
Good afternoon, Eric Runge with the law firm of Dave Pitney at 1 Federal Street and representing SouthCoast Wind.
Hello. Let's talk. Hello. Here I am. I'm attorney George X. Pucci for the intervener town of Somerset.
Good afternoon. Appearing on behalf of National Grid, David Rosenzweig and Erica Hafner from the law firm of Keegan Worrell, and also appearing on the Zoom broadcast is Mark Riley, Assistant General Counsel for National Grid.
That's it? Good. Okay, great.
Thank you. Bob, the microphone may need to be turned on. Sorry? Microphone may need to be turned on. Let's give it a tap. Yeah, it's off on the side. Oh, be careful with that. We only had so many rubber bands.
Okay, but this is on now. You can hear me?
Yes.
We can.
Okay, good. Thank you. Good afternoon, Chair Tepper and members of the site. I'm sorry. Good afternoon, Chair Tepper and members of the Siting Board. My name is Robert Shea, and I am the presiding officer in this matter. I'm here to present the tentative decision and staff's proposed amendment sheet and to answer any questions you may have regarding this proceeding. With me here today are the other members of the Siting Board staff who worked on the case. Andrew Green, the Siting Board Director, Joan Foster Evans, General Counsel to the Siting Board, Wayne Wong, the Assistant Director of the Siting Board, and Tim Riley and Nathaniel Strasberg, who are both analysts on the Siting Board staff. The project's purpose is to connect a proposed offshore wind energy generating facility to the New England power grid at Brayton Point Substation in Somerset. To connect these 2 points, the project would use 2 320 kilovolt direct current electric cables landing at the west side of the Brayton Point Peninsula and a converter station on Brayton Point. The offshore generating facility would be located in federal waters, and it is designed to ultimately generate up to 2,400 megawatts of electricity, although the project would use only 1,200 megawatts from the lease area. The offshore generating facility would be subject to the jurisdiction of the Bureau of Ocean Energy Management. The company also proposed a notice variation that would add additional conduits from the landfall to the converter station. The additional conduits could accommodate future transmission cables that may be needed to deliver the remaining 1,200 megawatts of intended wind generation capacity from the lease area. The tentative decision approves this project with the notice variation. Although the electric cables would be a total of 113 miles long from the offshore leased area to the Brayton Point landfall, only 2.1 miles of that length would be in Massachusetts waters. The majority of the cable route would pass through federal waters subject to BOEM's jurisdiction. The approximately 20-mile portion of the cables that pass through Rhode Island state waters and a land crossing of Aquidneck Island in Rhode Island is being reviewed by the Rhode Island Energy Facilities Siting Board. The Massachusetts portion of the transmission facilities is approximately 2.9 miles, including 2.1 miles in Massachusetts waters and 0.8 miles from landfall at Brayton Point to the National Grid substation. Onshore, the cables would run 0.6 miles underground from the landfall to the new DC to AC converter station. From the converter station, 6 345 kV cables would run 0.2 miles underground to connect with the existing 345 kilovolt Brayton Point substation. This existing substation formerly served the Brayton Point Power Station, the largest coal-fired generating facility in New England that operated for nearly 60 years until it was decommissioned in 2017 and demolished. The western side of the Brayton Point Peninsula is predominantly industrialized, but the eastern side is residential. The TD before the Siting Board today finds that the transmission project, including the notice variation, using the company's preferred route and subject to the conditions in the TD, meets the Siting Board's standards. Specifically, the TD finds that the project will provide a reliable supply of energy for the Commonwealth with a minimum impact on the environment at the lowest possible cost. Accordingly, the TD recommends approval of the SouthCoast Wind Energy Project. The tentative decision is detailed and comprehensive and covers many issues. I would like to focus my remarks on a few key issues, including 1, the need for the project, 2, the town's requested conditions, and 3, environmental justice populations in the vicinity of the project. Finally, I will present staff's proposed amendment sheet, which addresses comments and revisions to the TD, primarily sought by the company. The need standard applicable to this case was established in the Siting Board's decisions in Cape Wind and Vineyard Wind and reiterated recently in Park City Wind. All 3 of those decisions are also involved a transmission facility that would connect a new offshore wind generating facility in federal waters to the regional grid. The Siting Board has established a 2-part test to determine whether such a transmission facility is needed. First, the Siting Board determines whether the transmission facility would be able to interconnect to the grid absent the proposed transmission facility. Second, the Siting Board determines whether the new offshore wind generating facility is likely to be available to contribute to the regional energy supply. The first part of this test is easily satisfied here. The proposed offshore wind generating facility would be located approximately 51 nautical miles offshore of Brayton Point. Needless to say, there is no grid interconnection point located near the proposed offshore wind generating facility. Therefore, the TD concludes that the generating facility would not be able to interconnect to the grid unless the project is constructed. Regarding the second part of the test, the board's decisions in Cape Wind, Vineyard Wind, and Park City Wind require that a petitioner show, quote, indicators of project progress in order for the siting board to conclude that the generator is likely to be available to contribute to the regional energy supply. At the time the company initiated this proceeding, it had executed long-term power purchase agreements with Massachusetts electric distribution companies. In the summer of 2023, however, the company gave notice that it intended to terminate those agreements. The company represented that the existing power purchase agreements had become uneconomic due to, quote, unforeseen inflation, supply chain, and financing cost increases that affected the U.S. offshore wind industry, close quotes. The Department of Public Utilities approved the termination of the power purchase agreements in September 2023. After the company announced the termination of the power purchase agreements, the town of Somerset moved to dismiss or stay the proceedings on the grounds that the termination of these agreements should be disqualifying and demonstrating need to the siting board. At about the same time, the Rhode Island Energy Facility Siting Board stayed its consideration of the portion of the project that runs through Rhode Island because of the power purchase agreement termination. The tentative decision contains a ruling denying the town's motion. In the ruling, the siting board finds that the town's request is contradicted by precedent. In Cape Wind, Vineyard Wind, and Park City Wind, the siting board approved petitions to construct without requiring that power purchase agreements be in place. The ruling reviews the indicators of progress relevant to the project and concludes that the company has established that the generator is likely to be available to contribute to the regional energy supply. More recently, the company submitted a bid for the power from the offshore wind generating facility in a joint solicitation of Massachusetts, Rhode Island, and Connecticut. Last month, this bid was accepted by Massachusetts and Rhode Island. The company is now negotiating contracts with electric distribution companies for review by the Massachusetts Department of Public Utilities and the Rhode Island Public Utilities Commission. Furthermore, the Rhode Island Energy Facilities Siting Board has recently resumed its consideration of the project. The TD concludes that the company's generating facility has met the standard articulated in siting board precedent and that the project's interconnection transmission facilities are needed. The company and the town attempted to negotiate a host community agreement, or HCA, but ultimately were unable to agree on terms. In its post-hearing brief, the town listed a number of conditions which, if met, might satisfy the town's concerns regarding the project's impacts. The company has committed to comply with most of these conditions. The TD directs the companies to fulfill these commitments. The town's conditions and the company's responses are set forth in Table 26 on pages 234 to 242. The parties disagree on only two issues. The first is allowed work hours, and the second is whether the company should reimburse the town for the costs of consultants needed to assess the project's impacts on the town's residents. Regarding work hours, the company requested normal construction hours that are more restrictive than allowed by the Somerset Noise Control Bylaw. Specifically, the company requested construction hours of 7 a.m. to 7 p.m. on weekdays and 9 a.m. to 7 p.m. on Saturdays. The town of Somerset Noise Control Bylaw allows longer construction hours, specifically 7 a.m. to 10 p.m. on weekdays and 8 a.m. to 10 p.m. on weekends or legal holidays. Despite the bylaw, the town requested that the work be limited to weekday hours of 7 a.m. to 5:30 p.m. with no construction on state or federal holidays. The TD finds that the weekend and Saturday hours requested by the company are reasonable and consistent with the Somerset Noise Bylaw. However, the TD also finds that the town's request to exclude work on state and federal holidays is reasonable and should be adopted. The TD also includes a mechanism to address special circumstances that could arise during construction that may require flexibility. In such circumstances, requests for extended work hours will be subject to review and approval by town officials. The parties may come to the siting board for resolution of work hour disputes. Regarding compensation for the town's consultants, the TD does require the company to reimburse the town for those expenses, but there are protections for the company. The TD sets up a system whereby the town and the company have input into the scope of the consultant's work. Once that scope is agreed upon, the company must reimburse the town for the cost of the consultants. In the case of dispute, the company and the town are directed to negotiate in good faith. If no agreement can be reached, then parties may submit the dispute to the siting board staff. The onshore portions of the project are located entirely in the town of Somerset, which does not have environmental justice populations as defined by Massachusetts state law and policy. However, the preferred offshore cable route is within 1 mile of EJ populations in Fall River. As a result, the company was required to comply with MEPA's recently established public involvement protocol for EJ populations and its protocol for analysis of projects' impacts on EJ populations. Because the siting board is required to make findings in this decision on avoiding, minimizing, and mitigating impacts, including MEPA's review, staff carefully reviewed the EJ-related information collected by MEPA. The tentative decision makes 2 fundamental EJ-related findings. 1, that the project's impacts to EJ populations have been properly evaluated and that these impacts have been adequately avoided, minimized, or mitigated. And 2, that the project would achieve an equitable distribution of energy and environmental benefits and environmental burdens. The TD notes that the project over time will produce substantial reductions of air pollution and greenhouse gas emissions, benefiting both EJ and non-EJ populations. Additionally, the company has committed to providing a substantial number of new jobs, economic development opportunities, and clean energy training programs for both EJ and non-EJ populations in the project area and the South Coast region more broadly. The siting board issued the tentative decisions to the parties on Friday, September 20th, 2024. We received comments from South Coast Wind, National Grid, and the town of Somerset. None of the limited participants submitted comments. Staff have provided an amendment sheet that reflects requested changes to the TD. First, I'll look at the company's requested changes. The company has requested modification of several conditions in the TD. Condition C prohibits the company from commencing construction until it receives a record of decision from BOEM. The company requested that we add language explicitly allowing the company to engage in a variety of pre-construction activities, particularly those related to procurement of equipment and services. In response, the amendment we proposed would explicitly allow the company to, quote, procure equipment and services, close quotes, before it receives a record of decision from BOEM. The reason for this amendment is that the TD prohibits construction prior to the BOEM issuing an ROD. Construction, however, as defined in Chapter 164, Section 69G, includes, quote, contractual obligations to purchase facilities and equipment, close quotes. Therefore, as the TD is now written, the company could not sign contracts for equipment or services until BOEM issues its ROD. We believe that it is appropriate to allow the company to engage in contractual obligations to purchase facilities and equipment, given the long lead times for procurement and the potential costs of delay. Furthermore, the company and not the ratepayers are at risk if these contracts cause any financial issues. In addition, the change to condition C does not allow the company to commence physical construction before the ROD, absent explicit approval by the board. The next condition, condition D, requires the company to consult with the Massachusetts Division of Marine Fisheries on post-construction inland fisheries monitoring. The company requested that the language be changed to reflect that the company has been and is currently consulting with DMF. The staff has made that change in the amended condition D. We also amended the condition to require the company report annually to the DMF and to the siting board on post-construction inland fishery monitoring activities. The third requested modification relates to three conditions: condition G, condition I, and condition P. In condition G, the board directs the company to develop a noise evaluation and mitigation plan as part of its construction management plan. Condition I requires the company to develop an air quality management plan. Condition P requires the company to comply with the commitments it made to accommodate the town's concerns as set forth in Table 26. Condition P makes such compliance by the company a condition for receiving zoning relief. The company asks that we add language to each of these conditions that would allow the company to come to the board to adjudicate any disputes between the town and the company regarding the company's compliance with these conditions. We suggest that the board not accept this proposed change. As a general matter, the company and the town should create a mechanism to resolve any disputes that arise during construction and operation of the project. The parties and not the siting board are the best and most efficient entities to make timely day-to-day decisions that are necessary for a project such as this to move forward within the parameters of this decision. Condition G requires the company to develop a noise evaluation and mitigation plan that complies with the Mass DEP noise regulations at 310 CMR 7.10 and the Somerset Noise Control Bylaw. The siting board does not have the authority to waive or alter the Mass DEP noise regulation or the Town of Somerset bylaw, and has not done so here. The company is committed to complying with these noise limits, and the decision assumes that it will do so. Condition I requires the company to develop an air quality management plan in consultation with the town's designated consultant. The company is expected to work in good faith with the consultant, but the company will determine what final details are included in the air quality management plan. Therefore, the company's request for the siting board to adjudicate potential disputes between the company and the town is unnecessary. However, in the amendment sheet, we do propose a few minor edits to condition I to make it clearer that the town's consultant will have input into the air quality management plan. In condition P, we require the company to comply with the conditions set forth by the town, which are shown in Table 26 of the tentative decision, which cover many areas concerning the project. Again, the parties are best positioned to resolve disputes to their mutual satisfaction. Conditions L, M, and N all address magnetic fields, and each condition requires the company to conduct a study or test to measure magnetic fields and to report the results to the siting board. The company requests that we combine all these conditions into one, and we have done so on the amendment sheet. The company also requests that the reports required by the three conditions be combined into one report, and that such report be due within 1 year of the project becoming fully operational. We have also made this change. We denied one change requested by the company. The company asked that no testing or study be required, only that the company should be obligated to consider the need for such tests. The condition as amended still requires the company to conduct such tests. Condition O requires the company to report to the siting board every 5 years regarding the latest projections for sea level rise and flooding risk that could affect the project, and for the company to propose any necessary further mitigation measures to address such risks. The siting board would then have the option of directing the company to impose additional mitigation measures if necessary. The company's proposed revision would eliminate any possibility that the siting board could require the company to implement additional mitigation measures in the future. The company states that imposing such a condition would, quote, open up too much risk that additional infeasible or uneconomic mitigation measures could be imposed on the project. We recommend against adopting the company's proposed revision. The siting board has imposed this exact condition in previous decisions issued in the East Eagle project change case and the Beverly Salem case. The project, specifically the converter station, sits on a peninsula surrounded on multiple sides by water, which makes this condition especially applicable. In addition, the project would result in substantial projection of clean energy to the grid, and the reliability and resilience of that energy supply is critical. We believe it is vital to retain the right to require the company to impose additional mitigation measures as may be necessary in the face of potential flooding risks in the future due to climate change. Condition T requires that the company report on its progress towards its commitment of filling at least 75% of operations and maintenance jobs with local residents. The company requests that the language be changed to state that 75% of the operations and maintenance jobs are, quote, locally based, close quotes. The staff is willing to change the language in the condition somewhat, but not to the extent requested. Our proposal is that the condition should read that, quote, at least 75% of operations and maintenance jobs will be hired locally, close quotes. This language aligns precisely with the company's commitment made in the record. Now, turning to National Grid requested that we delete language from page 205 of the TD that noted concerns in the MEPA EJ review surrounding air modeling and cumulative impacts, and provided guidance to future applicants on addressing these issues. National Grid notes that these issues are under review. Excuse me. These issues are under review as part of an ongoing legislative discussion on clean energy infrastructure siting and permitting reform, and would be subject to future regulatory implementation. The revised language identifies these as concerns that arose during MEPA review, but limits consideration to the issues in this case only. The company identifies certain typographical errors and provides updates on certain permit activities. The amendment sheet includes these changes, except for some minor typographical errors, which are not included on the amendment sheet. In conclusion, the tentative decision finds that the South Coast Wind Energy Project, subject to conditions, will provide a reliable energy supply with a minimum impact on the environment, the lowest possible cost, that it is necessary, serves the public convenience, and is consistent with the public interest. And now we'd be happy to answer any questions now or later in the meeting.
Does anybody have any questions for the staff?
I have a few. Thank you very much, Presiding Officer Shea, for that very detailed overview. I just have 3 questions for you. So the tentative decision states that the project will contribute to the equitable distribution of energy and environmental benefits and burdens. Can you just walk through how staff arrived at that analysis and conclusion?
Yes, Mr. Green wrote most of that section, so I'll defer to him.
Sure, I'd be happy to address that. So there were a few different elements that came into play in looking at the test that's delineated in the Roadmap Act statute on environmental benefits and burdens and energy benefits, or did I get that mixed up? So one of the primary benefits of the project, environmental benefits, is the emissions avoidance, that once the project is operational, it will wind up displacing other resources that are being dispatched currently, which New England is still substantially a fossily based generation fleet. So even if it's among the cleanest fossil units being displaced through wind generation, that's still quite a bit of emissions. So there were, the record had, the tonnage of how many avoided tons of NOx, SO2, CO2. This project would basically displace off the grid. So that really is one of the chief environmental benefits of the project. And obviously that's a widespread benefit. So it affects both the EJ populations and certainly the non-EJ populations. And that's of global significance when we're talking about greenhouse gases. Certainly another benefit that was mentioned in the TD is on the sort of economic side of what the project will mean in terms of job creation, economic activity, procurement, training opportunities. The company has made some very specific commitments, which Mr. Shea was referring to in one of the conditions that we modified about the allocation of operations and maintenance jobs that are being targeted for locally based employment opportunities. There were, I guess, economic calculations that were developed in the record that we referred to in the decision on dollars of procurement that the company was looking to try and place locally if practicable, I believe was the word used, and other construction and engineering positions as well would be, again, targeted for opportunities in the local area to a significant degree. The reason that the economics do matter in terms of this balancing of benefits and burdens is that, the very definition of environmental justice populations has an economic component. So in the majority of the census block group areas, the economic characteristics of those census blocks were one of the reasons that they were considered environmental justice populations, meaning that the income levels are below 65% of the state median income. So we can't say precisely or for certain that this project will elevate, the average income levels in the census block areas nearest to construction activity above that 65% level, but certainly directionally, the project is going to provide higher incomes and more jobs. So that could, directly help actually potentially move some communities out of the EJ population category. That may be, an inference, but it directionally we would say that's correct. And then the other component that the TD notes is that, and this was actually pointed out by DEP in their development of the cumulative impact air regulations, that there's a socioeconomic component to a number of different health indicators, which we also use in tracking how disproportionately impacted an EJ population is. So COPD, heart disease, and other cancers and things of that sort actually do have an economic or socioeconomic component that has been proven statistically with epidemiological data. So again, income, let's say positive economic impacts of the project could help ameliorate some of those health indicators. So those were really kind of the key factors, I think, that we looked at in terms of reaching the conclusion, as well as the fact that the project itself is it followed that hierarchy of avoid, minimize, and mitigate in terms of the identified environmental impacts. So what's left is really a lot of benefits, fairly few impacts limited to the construction phase, and those are heavily mitigated and minimized with, where fossil fuels are used in vessels and construction vehicles. We're talking about low sulfur fuels. We're talking about the possibility of shore-to-ship electrification of the vessels so that they're not running diesel generators to produce power for laying cables and doing other things. That's a long-winded answer to your question, but hopefully I think it pretty much brings everything that we really wanted to emphasize in the decision for the discussion.
Thank you very much, Director Green. Very helpful. My next question is about magnetic fields. So SouthCoast Wind noted in its comments that it saw one condition regarding the consideration of the magnetic field frequency testing, and that it would be difficult to study the impacts of the project as distinct from other utility infrastructure nearby. And I hear that staff is recommending that we retain the testing requirement and that the company report within 1 year of operation. Can you explain how frequently staff is wanting to see this testing? And do you think that the testing can isolate the impacts of the project?
Let's see, who did testing? Yes, Tim, go ahead, Mr. Riley.
Thank you, Presiding Officer Shea. There are definitely ways to do that. We think that a confirmatory testing that right now the estimations of magnetic fields was based on modeling and really modeling only, and for good reason. They haven't built the facility yet, but confirmatory testing at full load would give an idea of what the anticipated magnetic fields are. We understand that there is a attenuation quickly with lateral distance from the center line of the lines, the power lines. However, having actually those data would be very helpful to communicate to the public safety. In terms of distinguishing between other sources, because of course it's an industrialized site, Brayton Point. And there are certainly some, before turning the switch on and actually doing some baseline testing would help to understand what the baseline magnetic fields are in the area, turn the switch on, and then do the full load testing. And we want full load, Commissioner Rubin, because there's a direct proportional relationship between current going through the lines and amount of magnetic fields produced. So seeing this at full load would be very helpful.
Thank you very much, Mr. Riley. That's great. And my final question is about the record of decision from BOEM. Can you explain, does federal law allow a proponent to commence construction prior to a final record of decision? And does that include scheduling and the procurement language that staff is recommending?
I think that the federal law, the statute doesn't allow construction prior to the approval of a record of decision, but what construction, how does construction is defined in the federal law, I don't know what that is in regulations. Is it just defined as widely as it is here in Massachusetts?
Can I just add to that response? So BOEM in the record of decision and in its final environmental impact statement review that's ongoing, they look holistically at this project, certainly in the federal waters and within direct federal jurisdiction, which is really where their authority is primary and singular, frankly. But they are also looking at all the way to the point of interconnection to make sense of the entire project. Their jurisdiction doesn't extend to Massachusetts waters and land, though. That is left to Massachusetts agencies. So if, for example, the company, and I think this is probably their intention in the requested modification of the no construction prior to BOEM approval, if they were doing, some minor preparatory work or testing perhaps on the site, that would not be precluded by the status of, pre-record of decision. The federal authority is not that stringent and not that prohibitive. But the question about procurement, I do not believe that the record of decision would prevent the company from entering into the contracts and making agreements with service providers, which is basically the flexibility that we've adopted in this refined condition. And if I'm incorrect, please say so. But that's my understanding of how the federal authority works vis-a-vis the DEIS process.
Thank you very much. Back to you, Secretary.
Any other questions for staff? Okay, and we will turn to SouthCoast for comments on the tentative decision.
Okay, they'll be fairly short. Again, Eric Runge for the company. And I want to, first of all, just say thanks to the Siting Board and staff for your role in the decision on this important public policy project today. And throughout the proceeding, we have really appreciated the diligence of staff and their thorough analysis and findings based on a well-developed record in this proceeding. And it's all reflected in the tentative decision and in the amendments that staff is proposing. I do want to introduce other SouthCoast Wind representatives, but I also wanted to say that throughout the development of this project, the company has been a good neighbor in Somerset, and it will continue to be a good neighbor there. We will work with the town and the Siting Board to ensure that development of and operation of the project is done in a way that minimizes environmental impacts. And so, again, we urge the Siting Board to approve the tentative decision with the staff's proposed amendments as final. So if I could, I would like to introduce the people who are here with me today from SouthCoast Wind. Sitting right next to me is Jennifer Flood. She is the permitting director overall for the project. And next to her is Kathleen Freeman, who is the person in charge of a lot of the state permitting stuff. You probably know her from the past here at the DPU and the Siting Board. Behind me, I have Kelsey Perry right behind me, and she is the outreach person who is involved in discussions with the town and outreach on EJ matters and other matters as well. And next to her is Kelly Smith. She's sort of the engineering lead for the project, especially for onshore construction. So if you have technical questions, I will point to her as the person who can answer them. And Rebecca Ullman is here. She is External Affairs Director for Ocean Winds, the sponsor of the project. And finally, Lahib Lee is here, and she is helpful in all permitting matters for the project, so we appreciate her as well. So I think with that, I'm going to turn to Jennifer Flood, if I could. She just has a couple of short remarks for you. Jennifer?
Thank you. I'm Jennifer Flood. I'm the permitting director for South Coast Wind, and I apologize for my lingering cough today. I just wanted to reiterate what Eric Runge said. On behalf of South Coast Wind, we do want to thank the siting board and the staff and council for their good work in this proceeding. The tentative decision's approval of the petition is based on a thorough analysis and a large body of evidence developed in the proceeding. The tentative decision is firmly in line and supports the achievement of public policy requirements of the Commonwealth, including those specifically focused on climate change, clean energy, and offshore wind as a fundamental component of our energy supply mix for the next several decades. Our company and our project of South Coast Wind was established to respond to those mandates, and we're diligently pursuing project development for the achievement in a complex and evolving industry and regulatory environment. We strongly support the tentative decision's approval of our Section 69J and Section 72 petitions to construct and operate the project, and the Section 40A petition to grant necessary zoning exemptions that will enable timely, efficient, and cost-effective development of the project. We urge the siting board to maintain all of those approvals and grants in full. As has been said, there were a few items in the tentative decision where we suggested some changes. We have reviewed the staff amendments and believe that they achieve what South Coast Wind wanted and do improve the overall tentative decision. We really appreciate the staff's consideration of our comments and support the adoption of the amendments. We believe that the tentative decision is thorough, well-reasoned, consistent with precedent, and protective of health and the environment. South Coast Wind looks forward to continuing to engage with agencies of the Commonwealth, including the siting board and its citizens, and as we continue our efforts to maintain large-scale offshore wind with a fundamental part of the energy supply for Massachusetts, Rhode Island, and the region. Thank you very much.
Thank you. Does anyone on the board have questions for the company?
Thank you for the comments. The company makes several references to its commitment to hiring local residents and providing workforce training to women, people of color, Indigenous people, and Native Americans. Has the company established targets for its hiring, and how is this local hiring being defined by the company?
Okay, can everyone hear me? Okay, Kelsey Perry, I'm the External Affairs Manager for the company. So we are definitely committed to hiring locally in the region. We have a swath of workforce development programs that we've been working on with nonprofit partners in the region to make sure that people are trained and getting the certifications needed to be able to apply for these jobs when they're available. In terms of targets, the target that we have right now is the 75% commitment to hiring locally during the operations and maintenance phase of the project. During construction, as of now, we do have an MOU with the National Building Trades to eventually sign a project labor agreement for the first project for construction. And also recently being awarded in Rhode Island means that we'll enter into a labor peace agreement for the operations and maintenance portion of the project as well. So those labor agreements will help us continue to make sure that the project is offering local opportunities for work. don't think we have any other local targets to point at internally. It's really just that 75% commitment as of now.
Thank you. And local, do you mean Massachusetts and Rhode Island? Do you mean a section of Massachusetts, a section of Rhode Island? Can you just say a little bit more about your geography?
Yeah, so we are definitely a southeastern New England project, connecting to Brayton Point and traveling through the Saconnet River. We haven't formally defined local, but local to us means southeastern New England, focused on Massachusetts and Rhode Island.
Thank you.
Yep.
Anyone else? I have a couple questions. Mr. Brand, when do you expect that the project will first provide power to the grid?
Our commitments and our power purchase agreement recently awarded in Massachusetts and Rhode Island are committed to 2030.
And when are you expecting to have the whole project online?
Both projects, so
The whole project that you're applying for here?
by the end of 2030.
By the end of 2030. So do you anticipate that you're going to be getting the project online throughout 2030?
Right now, yes, I believe so. I don't have, unfortunately, more specifics.
Can you talk to us a little bit about the converter station and the construction, the work that you did to think about future flood risk?
Sure, this is Kelly Smith. I can take that one. Fortunately, the site that we've selected for the converter station already sits outside of mapped 100-year floodplain. It also sits outside of the projected floodplain and storm surge conditions through the lifetime of the project. So we did use the MEPA RMAT tool to look at that mapping. So through the baseline siting, we're already at a very good location with the converter station.
Thank you.
Could I interject? I'm being told that the interpreters would like us to slow down a little bit while speaking.
Sure. Thank you. Thank you. That's helpful. Can you talk to us a little bit about how you're going to make a decision about ship to shore and whether you're going to be able to do that?
Sure. I think it's something that we'll continue to look at as we work to bring our construction vendors on board. I will say that particularly with the ships and vessel work to install the horizontal directional drilling trajectories, it is going to be one of those construction elements that's going to rely on existing infrastructure available at Brayton Point. So a big piece will be comparing the timing of our work to the infrastructure that's already available on site. I think we already spoke to that a bit in the record request and information request responses. So I do see that as a challenging area of construction to switch over to electricity, but it is one that we will look at as a result of the conditions.
The condition.
Conditions.
So do you anticipate having a contractual relationship with the ships that would require them to be available to use ship to shore?
I think through the procurement process, we will work with our construction vendors to understand what the options are for electrifying construction vessels and equipment onshore. We expect to have direct contractual relationships with the tier 1 suppliers, and we're evaluating whether the horizontal directional drilling providers will be tier 1 or whether they'll be subcontracted as tier 2, but it's certainly something that we will push on with the supply chain.
And can you tell us what the current situation is with the negotiations with the town and how discussions are going there?
Sure. Yeah. My colleagues who aren't here are leading discussions with the town on a host community agreement and also a TIF, a tax increment financing agreement. So we've been in deep discussions with the town for more than a year now, and discussions have ramped up the past several months. And I think we are hoping to go to special town meeting in Somerset this fall for a vote on the TIF. We're close to alignment on that with the town. And then negotiating a host community agreement is following right behind that. So we don't have any updates, but we're really in the weeds of back and forth with them.
I mean, it did sound like from the materials that we had that you were close, and then it didn't appear that that happened. So I was wondering if there's something that right now is holding that up, or if just discussions just continue.
Discussions just continuing. I think there were a lot of discussions on the host community agreement about a year ago. And then we started conversations on the TIF, which kind of took over the host community agreement conversations. Now that we've been focusing on the TIF, the HCA has taken a bit of a backseat, but we're aiming to negotiate those in parallel. And we are hoping to get to some type of agreement this fall, given we're looking at construction, next year. So yeah, we're really focused on that and are in a weekly, at this point, back and forth with the town.
So maybe we can talk to the town about that in a minute, about how the town feels about that. The last thing I was hoping we could discuss is emergency preparedness. And maybe if we could actually look at the language that's in the order right now. I think it's on page 106. One thing that we noticed during the current situation with Vineyard Wind is that the emergency preparedness agreements that they had were all focused on oil spills. And they really didn't have any kind of emergency plans for anything other than an oil spill. And they took the plans that they had for the oil spill and tried to then shoehorn them into the situation that they were in. So my concern here is thinking ahead to contingencies that we may not have thought of, like a blade failure in that case, but there could be many other. This is a new industry here in America, and these emergency plans are the first that we're going to have here. So what I'm raising here today is my encouragement that your emergency response plan includes more than the typical emergency response plans that we've seen for oil and gas and for work in the water, and really thinks about the kind of project that you're building here today and the kind of project that you are going to have in the future, and what kinds of emergency could come up that should be included in this plan, including very specific community outreach plans about who you're going to call, when you're going to call them, how you're going to communicate with the state, how are you going to communicate with BOEM? I mean, very detailed plans so that when you have an emergency, you're pulling them out and you're going through the plan. That is not what we have seen so far. And the way this is written right now, it doesn't quite get enough at what I'm talking about. I mean, it does talk about damaged offshore and onshore project components that impact Massachusetts waters or coastal area. But like with respect to the names and telephone numbers of federal agencies, it's to be contacted in the event of a spill or a hazardous materials. That's not the only time, obviously, that you would want to contact local officials. So I'm not necessarily suggesting that we change the language that is here in the opinion. I think it could be read broad enough to include the things that I'm talking about, but I do encourage you to look at this with a mind of this is the kind of project that we are doing today that is very different from the kinds of projects that we wrote these plans for in the past. Commissioner.
I would echo that and just add on, taking seriously the lead in language, on page 108, at a minimum, the plan should include those following elements. Really, that's the true minimum. So also recommending, based on what we've seen in other instances, having clarity on who is doing what. At what point in construction in particular are your various tiers of subcontractors making those calls? Having a coordinated plan and point of contact who is responsible and accountable for those types of communications will be really important. And we would encourage you to feature that prominently in your plan and keep it updated. As we all appreciate, points of contact on your end, the company's end, and on local, state, and federal ends all change. So keeping those current, so when you need it, you're not dusting it off and trying to make those adjustments on the fly. But this should be a living document that really enables you to be spry and responsive if needed.
And the only other thing I would add is particularly, when there are workers out on the water, which there will be during construction and during operation, the plans also need to include what happens to evacuation of the workers. How does that happen? who's in charge of that, whether it's the contractor during construction, what is the role of the owner when something like this happens. So you can hear that we're nervous about this particular issue because we now have some experience with it. So hoping that we can improve upon it in this project.
Secretary, Commissioner, I'm Becky Ullman for South Coast Wind. Thank you for your comments. I think it is imperative that South Coast learn from what's happened over the past 3 months, and you have our commitment that we will do that. Thank you.
Thank you. Appreciate it. Okay. Any other questions? All right. Well, thank you very much. Move on to the interveners. We have 2 interveners, the town of Somerset. So why don't we start with town of Somerset? Whatever you prefer.
Used to standing.
Sure.
So-
Good afternoon, sir.
Okay. Good afternoon, Madam Chair and members of the board. I'm George Pucci here for the town of Somerset. We intervened in these proceedings as stated in the description. You had referenced the open meeting law earlier, Madam Chair. Between the time of the tentative decision and today, the Board of Selectmen in Somerset has not had an opportunity to meet with me about the decision. I have been in touch with various witnesses who testified on behalf of the town at the siting board proceedings last summer. I've been in touch with the conservation agent as well as the town administrator for Somerset with a summary of the decision and my recommendations. I can tell you that the preliminary response has been overwhelmingly positive. The town is appreciative of, first of all, the thorough hearing that we obtained from the siting board. Particular credit, all the staff members of the questioning during the proceedings was very thorough on all issues. The presiding officer often had to deal with me in a very patient way and sometimes my inartful cross-examination, and we're appreciative of his efforts and of keeping this matter moving in a meaningful way. So we wanted to express our appreciation for that process. Basically, in terms of, and I should mention as an aside, the comments about a emergency response plan are well taken. I happen to just have some personal experience assisting special counsel for the town of Nantucket on the blade failure for the existing Vineyard Wind project. And, one of the lessons from that is to come out with a more robust emergency response plan for incidents like that. That wasn't so much, at issue in terms of the town of Somerset's concerns in this, but that incident has occurred since the time of the hearing last summer and today. And I just wanted to say that those points on that are very well taken. There were some limited concerns that were addressed by town residents and the panel of witnesses that we put on last summer. This is a brownfield site, as you know. There's a concern over movement of soils on that site, release of potentially contaminated areas into the air, particulate matter 2.5, particulate matter 10. There's a downwind neighborhood from the peninsula that is directly affected from anything that is released into the air from that project site that goes down to that downwind area. There was a land court trial on the after the closure of the coal-fired power plant. There was a scrap metal operation there that resulted in a very contentious land court trial where ultimately, thankfully, the scrap metal operation was shut down and those concerns were met. So, the town is pleased with, responsible improvement of a brownfield site as long as it can be done in an environmentally sensitive manner for the neighbors. Air quality concerns. The issue came up, of course, about noise, particularly with the horizontal directional drilling. Residents have a concern about that, listening to that day and night. magnetic fields are always a concern in these types of matters. The siting board addressed it, at least in my opinion, in accordance with the current state of the information and best practices with regard to the limited knowledge that we have of that. So, there would be no objection to that. So, to conclude, basically, the select board is scheduled to meet a week from tomorrow in executive session to discuss the decision with me. It is my expectation that the Board of Selectmen will be fully supportive of the decision and will not be interested in filing appeal of the decision if it's issued in accordance with the corrected version that's before you today. In terms of and just to conclude, in terms of the host community agreement, without characterizing it, we were unable to reach agreement before. Active discussions have been sort of on hold for a while on that. The siting board in the decision gives quite a sense of urgency, directing the company to report back in 30 days. I've advised the town administrator of that 30-day deadline. I'm going to discuss it with the select board next week, and hopefully with the impetus of that condition, a nice 30-day deadline. Deadlines are great things. Hopefully we can get some, active, robust discussions. But to conclude, on the off chance that the parties are unable to reach a host community agreement, in my opinion, and I will be recommending to my client, the siting board's decision does provide adequate conditioning on the issues that were raised by the town in the siting board proceedings last summer. Thank you.
Thank you very much. Does anybody have any questions? So I guess I just want to make sure that I understand sort of where you are right now today. So you do not have any changes that you're looking to make in the conditions that were outlined in the decision? We do not, no. We don't, saying that though, based on what is now before you, the siting board had produced a spreadsheet of proposed final corrections. We're in agreement with that, including, a little bit of the tweaking of the language as specific to the conditions related to the town. As long as the decision is issued in accordance with the recommendation, again, I haven't been able to meet with the Board of Selectmen, but it would be my recommendation that the town is satisfied with that. I mean, it puts us in a little bit of a difficult position in terms of not having met with the select board, just because you can't represent that the select board is in support. It's hard, and as you may imagine, I mean, I have to err on the side of caution on that type of thing. Of course. I did speak to the town administrator, who acts as their agent for town business, from an executive perspective. He was very pleased with the decision. He testified in the proceedings last summer. So, it is my expectation that the board will be fully supportive. I just cannot represent to you today because I have not met with them yet in executive session. But you're not asking us today to delay our decision? I am not. Okay. Okay. Any other questions? All right, Mr. Rosenzweig. Thank you, sir. Okay, thank you. Good afternoon.
Good afternoon, Secretary Tepper, board members, staff. My name is David Rosenzweig, and I've been representing National Grid in this proceeding. National Grid is an intervener in the proceeding, is the interconnecting utility. As such, it will be responsible for safely and reliably delivering the power that's being produced by the SouthCoast Wind Project to the electric grid and to its customers. National Grid is a supporter of the SouthCoast Wind Project. We need SouthCoast Wind and several other like projects to meet the Commonwealth's very important emission reduction goals. And as such, National Grid supports the project and the siting board's tentative decision and hopeful approval of the project including the staff's recommended amendments that were distributed yesterday. National Grid did have one concern that was addressed in the staff amendments concerning the treatment of cumulative impacts. I don't need to go into that in any detail at this point unless the staff or the board wishes, but we would ask that the board adopt the tentative decision with the staff amendments as its final decision in this matter. Thank you.
Any questions for Mr. Rosenzweig? Okay, thank you. Do we have limited participants?
Yes.
There are several limited participants in the proceeding, and I think a few have informed us that they would like to comment today. None of the limited participants submitted written comments on the tentative decision. So I'm going to invite each limited participant to comment. So first we'll start with Commonwealth Wind, who is represented by Adam Kahn from Foley Hood.
I don't believe they are here today or online.
Okay. We will pass on them. Kathy Souza, are you online? Okay. Nicole McDonald, I see that you're online. Hi,
Yes.
good afternoon. Good to see you. Thanks for joining us.
Thank you for giving me the time. Can everyone hear me?
You can.
So my name is Nicole McDonald. I live in the Brayton Point neighborhood. I intervene as a limited participant. So I just had 3 points that I wanted to touch on that really sort of came up as a result of the tentative decision being issued and then the comments and then the proposed amendments. I first have a question. In reviewing the tentative decision, it does order the company to comply with the reimbursement request for the town of Somerset to have consultants. But the reference is to the consultants set forth in sections 8D, 4, subpart A, D, and H. I couldn't find subparts D and H. Could I just get clarification where those are or if that was a typographical error?
And we give the staff a minute to give you an answer on that.
Perhaps that would be a really clerical correction if we needed to correct it. Would it suffice instead of us spending a lot of time flipping through and finding these sections to go ahead and correct it?
I think that's fine, but I do think Ms. McDonald would like to understand what consultants we're talking about. Do you want to, does anybody know that? Or should you look and we'll go on to the next question? We can come back.
Well, the consultants, the town didn't specify any particular consultants. This is actually Mr. Prucci may be better to answer this, but did just generally say that it wanted to have consultants and it wanted the company to pay for it. Yeah, go ahead, Mr. Riley.
There's an air quality consultant, there's an LSP, licensed site professional, but there is also some latitude that the town has about precisely which consultants it might utilize. Is that correct?
Go ahead, sir.
Yeah, and I saw that same reference, no matter how many times you double back. I spent a lot of time trying to find it. Those letters cited are not.
Didn't work. Yeah.
I took it from context. You know, you go to, there has to be a construction management plan. There has to be an air quality plan. Those are the types of issues that any type of soil movement or soil management type of issues have to be submitted for the comment by the town's consultant. The town does have a engaged consultant that was involved in the wetlands matter, Rue Associates. I would anticipate that the town would be seeking to have Rue also be engaged on this project. So would be the air quality plan, but I think the air quality plan is incorporated in the construction management plan. So if you read the substance of the decision in detail, it would include all of these areas, anything involving soil management, air quality, any type of air quality containment measures, and also with regard to the noise level when the company is seeking relief, from the hours of construction, that they would have to consult through the town's consultants. That would be on all of the issues that were presented of concern. The air quality, including any type of downwind effect on the neighborhood, anything involving soil management, and just dealing with projects a lot. I would anticipate that this would really come to play most likely in the construction management, because that's usually when these types of issues are addressed.
Does that sound right to the rest of you? Ms. McDonald, does that answer your question?
So I guess I think what the decision contemplated, and if you review table 26, starting at page 234, the town had proposed conditions which included, the various required consultants needed for the town to comply with those. I envisioned that the intent was of the decision was to provide that mechanism of reimbursement to the town to have appropriate experts. My concern was that the condition as phrased talks about subsections that I couldn't reference in the decision. So I don't want it to be a loophole where, when it comes to the time when the town wants to retain a consultant and we go back to the four corners of the decision, I don't want an opportunity for the company to say, well, it makes reference to, it's not clear on that. So my proposal, my ask would be, if the board intended for the consultants discussed in table 26 to be reimbursed, if I could ask that that language be somehow incorporated into the decision. My other, I don't know if you want to respond to that, but my two other topics, do you want me to go into another topic or stay on this one?
No, I think that's fine. I think we can figure out how we want to deal with the language there in a minute. Yeah, go ahead.
My next concern, when I first read the tentative decision, I was very happy to see the conditions L, M, and N regarding the magnetic field testing. And then the proposed changes now essentially allow for testing to be done. The language that's referenced is for testing to be done once fully installed and operational, and then the reports are submitted within 1 year. I would ask two things, and it's been discussed at this hearing, that we're sort of hearing that even if that testing is done once the project goes online and is operational, there's going to be a contention, well, you can't tell us that we're responsible for those magnetic fields. So the board had actually discussed here today doing baseline testing. That isn't specifically written into the decision. My request would be that there be a requirement for actual baseline testing to be done now. And then I would ask that the testing be done as soon as the project is producing electricity that's going onto the grid, and that testing be done in a relatively short window. The original decision talked about 90 days. That testing be done and produced to the siting board as well as the residents, so that we know what is being generated from the project. A 1 year time frame before anyone tests or knows what the results of the testing is, that's 1 year potentially of exposure to magnetic fields to a very densely populated area in Somerset. And there's really no need for that exposure. Once the exposure is done, we've been exposed, you can't undo it. So I would ask that the board go back to that original requirement that the testing be done as soon as it's producing electricity to the grid and within that 90-day time frame. My last ask, the change to that language, hiring local residents versus hiring locally. I'm an attorney, and words are very important in any legal document. I read that as potentially being a loophole, that instead of hiring residents from this region, and this project is intended to benefit this region, If you say we're going to hire locally, does that mean that you can have workers come in from out of state, but because you bring them to the office in Fall River or to the facility in Somerset and you technically hire them there, does that mean that you've hired them locally because that act of hiring them took place locally? Or does it mean that you actually have to have the pool of workers and people that are going to benefit from this be local residents? So I understand why South Coast requested that change. I would ask the board consider going back to its original language. Let's use local residents. Let's have this project benefit this local region. And then last, I just wanted to extend my thanks to the siting board. I've never been through this process before, but I truly appreciate the time and effort that the siting board members took. They listened to the residents. They allowed us to have an opportunity to speak. I think the original decision as written spoke to those issues that the residents raised. Somerset is, and the surrounding community, it's densely populated. I really appreciate the professionalism. I don't think I've ever seen a board work harder and be more compassionate and concerned for what this project is doing, not only to the residents, but the environment and the overall long-term outlook for this entire region. So I truly appreciate that, and I thank you for your time.
Well, Ms. McDonald, thank you very much for your time. We know that it takes time and effort to participate in these proceedings in any way, and appreciate the fact that you took your time to participate and provide us with your comments. And I think we'll wait to talk about your suggestions until we hear from the rest of the commoners and we have a motion on the table. Thank you. Who was next? Mr. Patrick McDonald.
Good afternoon. My name is Patrick McDonald. Nicole obviously is my wife. I'm a resident of Brayton Point. I've been a resident of the town of Somerset for 26 years. My kids went through the town of Somerset public school systems, and I've lived in both sides of town in Somerset, in the north end and the south end. And the siting board's got to know that there's always been kind of like we're Brayton Point and we're it's okay to pollute on us. But I appreciate the siting board listening to us, because that's what we went there and said, hey, it's 2024. We've been polluted on since 1959. The people of that area, there's been a huge cancer cluster. I'm a cancer survivor, I think, from Brayton Point. My father's a cancer survivor, I think, from Brayton Point. So anything that the board, that the energy secretary can look at and make this a strict requirement to South Coast Wind. We're not against South Coast Wind, and I've seen Kelsey all the way through and familiar with all the panelists that have been on South Coast Wind. None of us have ever swore at each other, raised our voice at each other, but we've been raising our concerns to them at every meeting we can in the town of Somerset and the town of Swansea. I don't want to repeat what Nicole said about EMS, but we're all really concerned about that. We're all really concerned about the noise from the converter station. I had asked that it be put in the building, but I don't see that really happened anywhere in the decision, which I'm kind of disappointed with. I hope that there is some type of maybe amendment that could say, listen, if the noise is going to be a problem, you're going to have to close it off. I know they had some language in there about certain things that could limit noise, but I think that's more during the construction process than the overall when the project is done. And I just wanted to introduce myself to everybody that we are not receptors on Brayton Point. We are people. We live and breathe the air there, and we're entitled to live and breathe the air there just as anybody else is. You go home to your neighborhood, you're entitled to breathe clean air, have clean water. I was kind of disappointed about that the ship-to-shore power wasn't suggested as a condition during this horizontal drilling. And I know what that's been a big contention to us on Brayton Point is breathing diesel ships. And I know Ms. Tepp has ruled on another project that's coming down to Brayton Point to allow for the allowance of one diesel ship. And I just want to express to the siting board that many of us in our neighborhood don't want diesel ships at all in our neighborhood. Now, for the next project after that. So, and this is in closing, is that two things. you can't put in a public nuisance. I don't care if you're the Energy Siting Board or who you are. Recently, the appeals court came out with a case that's been decided during the comment period. This is April 12th of 2024. It was Keating Company versus the town of Acushnet. I'm sure that Ms. Tep might know about Keating Company and what's going on in the town of Acushnet. But just because the court came out in that case and said, just because something is properly zoned doesn't mean it can be a public nuisance. So I'd really like the panel to take a look at this and say, hey, listen, we can override all these zoning exemption, all these zoning rules and properly zone this, but you can never take it out of the public nuisance project. So we know that there's 2,400 megawatts coming. And we also know that Ørsted just came before the town of Somerset looking for a 2,000 megawatt converter station on Brayton Point. So that's 4,400 megawatts coming into Brayton Point. I didn't see any scientific data about whether you can live around 2,400 megawatts or you can live around 4,400 megawatts. And I really asked this board, tell me where else in the world is there that type of electricity coming within a half mile of my home, and even closer within hundreds of yards of other people's homes. So I know that you're looking at this one project, but you should also know that Ørsted was just in our neighborhood at our town meeting looking for another 2,000 megawatts. So that's 4,400 megawatts. So any conditions that are the most strict should be put on South Coast Wind, because if there's going to be cumulative converter stations down there, the multiple impacts have to be considered now versus not later. I don't think it's fair to Ørsted to come along and say, oh, we can't do it because South Coast Wind grabbed all the good conditions and now we're precluded. And now your energy goals of meeting 30,000 megawatts of electricity by 2035 is out the window. So we don't want to create situations like that, because this is a first of its kind project in the United States. I want to again thank Mr. Shea. He's been a great man. I'd like to thank the Energy Siting Board for listening to us. Just make it strict. We're people, we live there, no public nuisance. Thank you very much.
Thank you very much, Mr. McDonald, for your comments. Kathy Souza, are you on?
Good
Kathy.
afternoon.
Hi, Ms. Souza. How are you?
Hi, good. I would like to start by thanking the board as well as Mr. Shea for allowing us to speak, allowing us to testify, and really hearing what we had to say. That's rare for us. It's been a breath of fresh air. Your final or your draft decision shows that you really listen to us, and we appreciate that. I have just a couple of items to address that Mr. and Mrs. McDonald have already addressed, but one is the ship to shore power. A fun fact, everybody, keeps saying this was a coal community. This was a coal-fired power plant. The power plant had ship to shore power. They shut off their engines when they came in. Everything was done from the ground. All the unloading was done and the ship was shut off. The diesel ships came in when it was scrap metal. The fumes from those ships reach our neighborhood within seconds of that ship. Once it starts coming under the Mount Hope Bridge, once it comes within 1,000 feet of our neighborhood, once it pulls into the neighborhood, and for 10 days straight, it's diesel fumes. In a state where a bus is not allowed to idle outside of a school for more than 5 minutes, in a state where trucks are not allowed to idle outside of buildings for more than 5 minutes, this neighborhood is being asked to breathe in diesel fumes from a massive ship 24 hours a day for 10 days straight. And for a project that's promoting clean energy, this neighborhood and the Leaside neighborhood are being asked to breathe in diesel fumes for the good of clean energy. And that, to me, I just cannot wrap my head around. We had appealed the air permit for Prismium. Their air permit stated that they said that it was a mobile, a stationary mobile source. I might not be saying that right, but this is sitting outside our homes running 10 days straight, 24 hours a day. Now we're going to have 2 docks. Now there's the potential of 2 ships sitting outside our homes. We've never had that. We never had it before. Then we had it with scrap metal. Now we may have 2 ships, diesel ships, running at the same time 10 days, 24 hours. That's an enormous amount of diesel fumes blowing into a neighborhood, again, in a state that does not allow a bus to idle outside of school for more than 5 minutes. So I think that needs to have, not the we'll try, not we'll do our best, because I can tell you right now, nobody's going to want to do it. Let's put in the ship to shore power first, and let's go from there. Secondly, the emergency plan, I appreciate that being brought up. If you come down to our neighborhood, there is one road in that neighborhood and there is one road out. If there is a major incident with that converter station, I can promise you it's going to be responding vehicles, so fire department, every emergency you can think of vehicle coming down that road. I'm not sure that we're going to get out. So that has to be really well, it is one tiny road for all the emergency vehicles to get in and the residents to get out. So that has to be, like you said, a very detailed plan of who's calling when, how are the residents coming out? There is no alternative egress for us. We've complained about that, we petitioned, we've done everything we can for years to say, please look at this. We have no other way out. It's not properly maintained. The gates that we have to get out are constantly locked. We're reliant on the town police departments and fire departments to come unlock the gates and let us out of our own neighborhood if there's an emergency. So I would implore that that be a must-have before they start construction. Let's not wait for their construction team to come up with a plan. That should be a must-have in place before we begin this. Hours of construction, again, it's going to be horizontal drilling. This is a neighborhood that has probably 40 children that have come home from school. They have to do homework. They go to bed between probably the youngest at 7:30 to the oldest probably 10 o'clock at night. It's unreasonable to have those 3 hours. So to save money, all I keep hearing from South Coast Wind is economically benefit to them. But for our seniors, our young families to have to retrofit their homes, some can't afford air conditioners, will have to shut their windows. So the burden on the residents, I can guarantee you, is far more than the burden on a company that has the potential to make billions of dollars in the future, to do this right from the start. So I hope those would be considered as well. We are not an EJ community, but we have been subject to pollution time and time again through coal, through scrap metal. And I am just imploring this board to keep on the path. The first draft before I saw last night's condition was excellent. I really appreciate those. And I would really appreciate if you stuck by those first set of conditions that you had. I thought it was excellent. And again, I appreciate your time and letting me speak.
Thank you very much for your comments. Mr. Mendez?
I don't believe he's with us today.
Are there any other limited participants that are on the phone or online that would like to comment? Okay.
I believe Dr. Healy may be online. If you call his name, he's on the phone. Somebody would have to unmute his phone now.
Dr. Healy is not a limited participant, but he was a witness for the town during the proceedings, so it would make sense to call him.
Sure, I certainly, he's a member of the public. Be happy to hear
Absolutely.
from him. Mr. Healy, if you would like to speak, please feel free.
We're moving him to the panel.
Have we done that?
For some reason, we don't seem to be able to, I'm sorry, Mr. Healy is in the panel. Mr. Healy, can you hear us? And do you have a microphone active?
He appears to be muted still.
Nothing that we're doing here. Mr. Healy, could you unmute yourself so we can hear you? Not having much luck.
Okay, well, why don't we see if we can, if there are any other members of the public, and we can go back to Mr. Healy if we can fix that situation. Are there any other members of the public that would like to comment on the tentative decision today?
Oh, I'm sorry. We had talked about having a break around this time, so maybe we could take a short break.
We can do that.
Give our stenographer a chance to refresh himself and resume.
Okay. Mr. Rand.
How long?
10 minutes. Thank you.
Good so far. What?
I want to make sure I'm looking at the right place. I said it should just be table script after I'm there. Just make it, yeah, you know what it was? It was not a page, sorry.
Right.
That's all.
Oh,
It should just say table 26. Right? Yeah. She referred to page 243.
Table 26 is the easiest way.
It is.
234.
He said 234. Okay, thank you.
So you can say it's not 49.
He said, "We should understand." And stay.
They're not.
to shore, the emergency plan, higher level, nothing. was- Oh, okay.
But it's not,
Yeah.
it's the last.
Okay, let's go back on the record. So are there any members of the public that would like to comment this afternoon?
Hi, yes, this is Dr. Healy.
Hello, Dr. Healy.
Good afternoon, Chair Tepper. Thank you very much for taking the time here.
Happy to hear from you.
Good afternoon to Chair Tepper and the EFSB members. My name is Paul Healy, and I'm providing these comments as a private citizen of Somerset and a retired public health physician with specialty training in preventive medicine and occupational and environmental medicine. I believe I'm the only physician with this type of training experience to provide comments to the EFSB on this project. I want to thank the board for the opportunity to provide these comments. I believe there has been a robust discussion of the issues. The tentative decision acknowledges many of my concerns and provides a public health preventive plan to minimize cumulative exposures to the public and the environment from noise, odors, and oil and hazardous waste contaminated fugitive dust. Just to reiterate, South Coast Wind's project at Brayton Point will be a multi-year excavation and construction activity through soil contaminated with oil and hazardous materials. Currently, the site is categorized as having no significant risk or hazard because the contaminants are capped with the geomembrane barriers and clean soil. It will be transformed into a temporary significant risk or hazard site through South Coast Wind's excavation and construction activities. Preventive measures must be put in place to protect the public and the environment. The board's tentative decision captures many of those preventive measures and promotes the responsible development of the project while minimizing the threat of contamination to the residents and environment through its robust orders of conditions and integration with the town's orders of conditions, including the use of specialists such as licensed site professionals, industrial hygienists, people who can also monitor noise. The waterways are places where residents fish, boat, swim, and harvest clams. It's my hope the board will not modify the decision without further input of the town and residents. I am hopeful that South Coast Wind will be a responsible business and work collaboratively with the town and residents to proactively plan and assess to protect them and the environment through their work practices. Thank you for the opportunity to present today.
Thank you very much for your comments. Appreciate it. Are there any other members of the public who would like to comment today?
And if so, please use the raise hand feature if you are joining us on Zoom.
All right, hearing and seeing none. I think we will go on now to put a motion on the table so we can begin deliberations. So do I have a motion to adopt the tentative decision? Somebody make a motion. Can somebody please second it?
Second.
Okay, so we have a motion on the floor and we are going to leave that there and now we will deliberate. Let's deliberate first on the amendments. I'd like to do them in the following order. First, I'd like to discuss the references to the consultants, then ship to shore, then EMF, then construction hours, and then noise during operation. So do we have the reference up to the consultants resolved? Would
you like to make a motion for the to adopt the amendment, staff amendment sheet, and then second it, and then
Do I have to do that first?
Deliberating on that motion?
All right, I can do that. Sure. All right, can I have a motion to adopt the staff's amendments?
So moved.
Second.
All right, let's move on. Do we have the issue with respect to the consultants that we are referencing resolved, and do we need to change the language there? Go ahead, sir.
Thank you. Madam Chair, again, I did, I sort of, I don't know if it was even proper, but I went over there
That's why
to
we have
that area
breaks.
during the break.
That's why we have breaks.
And I did speak to Ms. McDonald on the phone during the break.
Great.
This doesn't address all her comments, but we agreed that on page 243, if you delete the reference to that section, which doesn't exist, if you double back, if you just delete that reference and reference table 26 there, because that table 26 addresses each instance where any consultant would be involved. Some of the subject matter overlaps a little bit. So you don't, in my opinion, you don't need further clarity other than to reference table 26 in that section. And that would cover all the issues for consultant review that are adopted by the siting board. So if you look at page 243 of the, bless you, if you look at page 243 of the tentative decision, the second full paragraph says specifically the siting board directs the company to comply with the requests for reimbursement made by the town of Somerset as set forth in. And so what we would propose is you strike the words section Roman 8, period D, period 4, paren A, comma, paren D, comma, and paren H, period. Strike that language and simply substitute table 26.
That seems to work for me. Does that work?
Yeah,
Go ahead.
I think that makes sense. And we would also need to amend condition Q, which has the same language. And I am supportive of that change.
Okay. I'm sorry, just give me 1 second. I have the governor texting me, so just give me 1 second. Okay, thank you. Okay, so do we have that taken care of? Yes? Okay. Staff's good with that?
Staff is good with the amendment. Let me note that that particular change is not on the staff amendment sheet, so we need to go through again a separate motion to make that amendment and then vote on it to adopt it.
Can we do it at the end?
We can.
All right. Unless you want to go ahead and make a motion now.
I just have one question for town council, whether you would want to retain that first reference to sub A so that the good faith consultation obligation is referenced later in the decision document as well.
Is there a subsection A?
There is.
Yes, thank you for noting that. Frankly, I
Okay.
missed it.
Sure. So let's, I will move.
So it would be in section singular 8D4A and table 26.
Correct. Mm-hmm. Did you want to do cleanup at the end? Or along the way?
Why don't we do it now?
Okay. So I will move to amend on page 243 and page 257 of the tentative decision, the reference to section 8D4 to reference only subsection A, not subsection D and H. So strike D and H and add a reference to table 26 in their stead.
Second. All in favor?
Aye.
Sorry, I do a roll call.
We have to do a roll call.
Yep, sorry. We do have a motion on the floor for the staff tentative decision. I just want to confirm with council, staff council, that we can take this additional motion on while the other one is pending.
Still on the floor.
Okay. All right. Sorry for that. Chair Van Nostrand,
Yes.
Commissioner Rubin,
Yes.
Commissioner Heipel,
Yes.
General Counsel Costco. General Counsel Costco. we- Thank you. Deputy General Counsel Dobbs,
Yes.
Mr. Bonfilio,
Yes.
Mr. Watson,
Yes.
and Chair Tepper.
Yes.
Motion carries.
Okay. All right, let's move on to ship to shore. I would like to hear a little bit more from the staff about the evidence that was submitted with respect to, in the case about the ship to shore and the feasibility of doing that, and whether there was any evidence specifically about whether they could make the port or the docking ready for ship to shore, and then see what the ships were. Whatever the evidence is, it would be helpful.
Thank you, Secretary Tepper. Yeah. In the SFEIR certificate, there's a paragraph in here. If you want, I could just read it. It'll take a moment.
Sure.
Okay, the certificate on the FEIR required the proponent to consider mitigation commensurate with the level of impacts from the air emissions identified, including supplying ship-to-shore electricity to vessels while they are moored to minimize or eliminate the need for onboard engines to generate power from fossil fuels. In supplemental information, the proponent commits to you including ship-to-shore power as a criterion in the evaluation of contracts executed with vessel operators. When utilizes the New Bedford Marine Commerce Terminal, the proponent commits to using the available ship-to-shore technology to the extent the technology can be integrated and is cost efficient to the vessels.
Cost efficient?
Yes, to the vessels utilizing for staging activities. In addition, the proponent commits to consulting with Mass CEC, Clean Energy Center, about potential upgrades to New Bedford Marine Commerce Terminal to accommodate ship-to-shore connections for larger vessels, and working in good faith with vessel providers to enable this. With the vessel providers. So basically, there's discussions as far as it's cost efficient and effective to work with the vessel providers. And as a criterion for evaluating vessel contracts, the company appears to be open to this possibility.
Yes, go ahead, Mr. Runge.
Madam Chair, Eric Runge, Counsel for South Coast Wind. If it would be helpful to the board, I could have Kelly Smith speak to ship-to-shore feasibility a little bit.
Sure, and Kelly, I would encourage you to think about how we can make this work and how we can get to a ship to shore, as much a ship to shore as we can. So go ahead.
I appreciate that. This is Kelly Smith for the company. I think that passage was instructive.
That mic is not working.
Is that on?
No.
How about now?
Yes.
Yeah, okay, thank you. This is Kelly Smith for the company. I was simply saying, I think the passage from the SFEIR was instructive in establishing where we were coming from when thinking about the ship to shore topic. I think what I've been hearing a bit today seems to be kind of conflating conditions where ships are moored at established docks and piers with support services versus when ships are being used on a temporary basis for construction. In the context of New Bedford Marine Commerce Terminal, that's a facility where we would expect to be doing work during routine operations, so having vessels there on a recurring basis. And we are committed to evaluating ship-to-shore feasibility and exploring emergent technologies in that context. What I heard from—
Can I just stop you there? What is the current technology there? Is it available at New Bedford right now or not?
Unfortunately, I'm not the expert to weigh in on that aspect of our plan. I don't know if anyone else. My scope is focused on the onshore transmission. I apologize. I don't have that
It's all
answer
right.
handy.
It's okay.
But with respect to the construction at Brayton Point, we're proposing to use most likely a jackup vessel for the construction.
A jackup vessel?
Thank you. For the construction of the horizontal directional drilling. And the way a jackup vessel stays stationary is by extending legs into the seabed. So it will not be set up at an established dock. It will not be at a pier with support services like the supply of water and electricity. So with respect to construction, we will continue to evaluate what sorts of technologies are available for electrification, but it is not as routine of an implementation with construction. So that's the challenge we see. But with respect to New Bedford Marine Commerce Terminal and operational conditions, it's a much more viable option.
So on the jackup, so just explain to us how does the boats pull up to this thing that's in the water?
So
And what do? They just sit there?
Yes, so the vessel will be stationed offshore in the Lee River, most likely a few hundred feet or so from shore. There will not be established infrastructure on the west side of Brayton Point.
Okay. All right. I understand. Okay. And right now it's not available to have that electrified?
Not at this time.
Mhm. And we're doing it that way because, why?
So for construction, the vessel will be there for a temporary period in time. It will be building new infrastructure. That infrastructure is not present to plug in the construction vessel.
Okay. Did you want to say something, sir?
No, actually, we're just thinking about it. We're looking at the things right now. I think that there's a, I'm sorry.
I think that there's a feasibility question. I think we're talking about a technical feasibility question about what is and is not feasible at this time. And so any additional information that allows us to evaluate said feasibility would be helpful from the company.
And remind me, you're going to use New Bedford for what? Staging? What are you using New Bedford for? Is it during, you're just using New Bedford during operation?
Becky Ullman for the project. We will be constructing out of the New Bedford Marine Commerce Terminal, and our operations and maintenance space will be out of New Bedford Foss. We'll also have some We will be operating out of New Bedford Foss Terminal. We will also have ancillary facilities in Rhode Island.
And what does the ship situation look like during that period of time? Like what ships are coming and going during that period of time?
Excuse me, Secretary, during construction or operations and maintenance?
So you're saying that you'll use one part of the terminal for our operation and maintenance, right? And one part for construction? No.
Sorry there.
No, I'm sorry. I'm sorry. I'm not being clear.
This is kind of new with our recent Kelsey Perry with the South Coast Wind. This is somewhat new with our recent award through Massachusetts. We're planning to use the New Bedford Marine Commerce Terminal for staging and construction of our project, and then the Foss Terminal also in New Bedford, but a separate piece of land, different landowner for the operations maintenance. So both based in New Bedford, but different plots of land.
And so what kind of ship activity will be happening at each place?
Yep. So we are still in the middle of vessel contracting. So we don't have the specific vessels yet that will be coming to the commerce terminal. We'll be using things like service operation vessels, SOV, crew transfer vessels, CTVs. But we're still, our CNP team is negotiating those contracts. So we can provide more information, I'm sure.
Would it be possible, certainly when the vessels are moored or are at dock, that, ship to shore, or shore to ship electricity is very feasible. would it be possible to add in something about an evaluation of on-water, operations where we're nearby the shoreline? I mean, basically, especially, we're talking about the preferred alternative is on the western side of the peninsula, on the Lee, the mouth of the Lee River. And the question is, could we add in something about the evaluation of feasibility where we're like 1,000 feet offshore or 1,500 feet offshore, where, evaluate the feasibility of that and kind of require that in a condition for on, near shore operations, basically. Because I think it's pretty obvious that, more to the dock, that's feasible. I think the question becomes the technical evaluation or technical feasibility of nearshore operations. That's the question. And so including in the condition, a technical evaluation and report pre-construction of the technical feasibility of nearshore, shore-to-ship electricity would be, I think, a good thing.
Well, right now, it directs that the company would consider the feasibility of supplying ship-to-shore electricity to vessels while they are moored. So you're saying that's feasible?
Well, we're saying there's docked and then there's moored.
Okay.
Right.
All right. All right.
We may need to correct that, but basically clarify that.
So how would you clarify that?
I'm sorry. That we would, require shore-to-ship electricity for docked vessels and evaluate the feasibility of near-shore operations, basically. Because, you're right offshore.
Right.
Secretary, if I may,
Say your name.
Becky Ullman for South Coast Wind. We would be pleased to continue to work with the EFSB on the feasibility of ship to shore, and especially in light of emerging technologies.
Okay. So while we're continuing to discuss, why don't the siting board staff see if you can come up with some language for condition E along those lines?
I do have a suggestion. I'm sorry. I do have a quick suggestion just to maybe resolve this. Since the condition is not obligating the company to use ship to shore, it's a consider and explore feasibility condition. There's no reason that can't be generalized to the topic of supplying ship to shore electricity to vessels and eliminating the while they are moored, and just saying to minimize. So that could include near shore. It could include in the Lee River. It could include anywhere, and not preclude the possibility of further electrification.
I guess my
Consider.
concern is that there is a difference between some of these things. Some of them are more feasible than others. And on the ones that are feasible, I'd like to just have them have to do it if it's feasible. Instead of, you know what I'm saying? I'm a little worried about lumping them all together.
Well, again, there is record information on the question of how feasible shore-to-ship electrification is. This is something that we looked pretty closely in the MEPA record, because this was a topic that came up repeatedly in MEPA, and the information in the record that I recall seemed to point to questions about vessel availability, global market. The company is trying to contract for vessels. There's probably a seller's market, not a buyer's market these days for a lot of the vessels that are critical for offshore construction. And so I think the word obligate becomes a scary word if we're talking about schedules and costs that are meaningful. So I think that's probably why MEPA used the language that it did of considering and encouraging, and we sort of emulate that concept and the conditions. So, that's the delicate balance that we're
Maybe
trying
I
to
don't
strike.
understand the technology well enough, but aren't there two parts of it? Isn't one part is the ship and whether the ship is available to use ship to shore. The other part is on the land
shore
side,
side.
on the shore side.
Right.
So what I'm saying is, to the extent that we have control over the shore side should be ready to take a ship that can use ship to shore.
I understand.
So is there evidence in the record to support the fact that that is feasible?
For New Bedford, I think we have evidence in the record that CEC is working to try and have that capability as part of the New Bedford Marine Commerce Terminal. I'm not sure it's commercially ready yet, but it is a topic that they had interest in, and that was in the record. As far as whether that technology could also be used in Brayton Point for things like horizontal directional drilling or laying cables, the record is not as clear on that, I would say. And I think Ms. Smith was indicating that, construction activity, electrifying the actual construction activity of running drills and other pneumatic equipment that's on the vessels, that may be a whole different order of business than just electrifying, sort of the parasitic loads that go on in vessels to keep refrigeration operational, keep motors, running and that kind of thing. But again, I'm not the expert in this area, and I'm citing what I remember from the record. So it would be helpful if the company could perhaps enlighten us on this point.
Can I make a suggestion?
Yes, please.
Would it work to modify current condition F to address these two needs? We could say we direct the company to, 1, use ship-to-shore electricity for vessels while they are moored whenever feasible, and 2, to evaluate the feasibility of supplying shore-to-ship electricity to near-shore vessels, and to minimize or eliminate the rest of that clause. Then we have both considerations, both moored vessels and near-shore vessels, while addressing some of the concerns that Director Green raises about the current availability of ship-to-shore for moored vessels.
I think you're talking about condition E, right?
Yes. Condition E. The rest stands.
Yes, and I think that's a good idea. What does the rest of the chair, what does the rest of the board think?
Is that okay with you guys?
I support that and have a further proposal to add a sentence at the end of condition E stating that the siting board directs the company to work with siting board staff on learning about the feasibility of shore-to-ship technologies.
Do I have a second? Okay. Bonnie, do you want to make a motion? Commissioner?
I move to modify condition E to read, the siting board directs the company to, 1, use ship-to-shore electricity for vessels while they are moored whenever feasible, and 2, to evaluate the feasibility of supplying shore-to-ship electricity to near-shore vessels to minimize or eliminate the need for onboard engines to generate power from fossil fuels.
What about the rest of it? What about the reports?
And to further add to the end of condition E, and to submit reports indicating its ability to use shore-to-ship operations 30 days prior to construction, 180 days after construction commencement, and 90 days after construction completion.
Second,
Second.
we have a roll call vote, please.
Chair Van Nostrand.
Yes.
Commissioner Rubin.
Yes.
Commissioner Heipel.
Yes.
General Counsel Costco.
Yes.
Deputy Counsel Dobbs.
Yes.
Mr. Bonfilio.
Yes.
Mr. Watson.
Yes.
And Secretary Tepper.
Yes.
Motion carries.
Okay, let's move on to EMF. Is there any board member that would like to talk about amending any of the EMF conditions? Remember, we have on the table right now the EMF provisions that were as modified by the staff.
which we have not yet adopted.
Right.
Can we take a 5-minute break so that I can propose some language?
Yes.
And I've been informed that the interpreters are having difficulty again with the speed at which everyone is speaking. So if you could try to slow down. Thank you.
Thank you for the reminder. Let's go off the record.
The additional comment that said, we don't want to wait 1 year for the exposure for a year, but I think the rationale behind waiting a year was that the project won't be fully loaded. We'll have that discussion. Yeah.
And then. But 90 days after it becomes energized, right, which is not full load.
Yeah, well, that's, say 90 days after full load.
Yeah, but this one's full.
I
First
understand.
turned on and full load.
That's why I'm saying it's performance, that's the minimum performance criteria, 90 days after full load.
Yeah, that's what I'm saying.
I understand.
Yeah,
I understand what they're.
And we said specifically at full load.
Why that's a marriage.
There's two issues. There's the baseline, that's just what the company said. And then there's when to. So I think that we should have a discussion about that. When the facility is energized, it's not going to be a full load. It's also good for the result. But you need the result for the.
Yes, that's definitely right.
Staff can do that for you if you would like.
I'm sorry, the microphone was actually muted for the Zoom audience, so could you just
Oh,
repeat what you
sure.
said?
Yeah.
I'm sorry.
Absolutely. So I think there are three different ideas here. So I think in general, I think the idea would be, one idea would be to have a baseline, do a test when it starts to operate, and then do a test at full load. Is that where you were generally going as well?
Yes.
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 Okay, so why don't you tell us what your proposal is?
We need to give one.
Use the microphone, please.
Thank
So
you.
if you don't have the language, it's all right. We probably have some up here as well.
We do not have the language. We did not write up language for the baseline. We agree with the 3 testing times. We do not have language for the baseline. However, we did institute testing in Park City Wind and suggest using for the times after the facility starts operating to use a similar type of language that we've already approved in Park City Wind.
That makes sense, but we would need to know what that is. Okay, you need to talk to your microphone.
Oh, I'm sorry.
That's all right.
Sorry.
That's all right. It's hard to remember.
Given the public.
Given the public interest in the potential health and safety risks from magnetic fields, the siting board directs the company to provide compliance filing within 100 days of each of the following milestones. For informational purposes, that shall demonstrate that the actual magnetic fields at the Craigsville Beach landfill, I have to replace that, are consistent with the modeled results it has presented in its proceedings. A, after first energization. B, when the facility is capable of producing 400 megawatts, 600 megawatts, and full commercial operation. For this condition, full commercial operation shall mean the date that the energy facility is installed and capable of delivering approximately 1,200 megawatts of energy.
I mean, the one point that I would make is that this is a different situation than when we're talking about something that's, a line that's going under a beach, or, I mean, this is far away from where people are. And, as we all know, EMF, gets much less very soon, as, very soon from where you move away from it. So I do think we don't want to overemphasize the fact that, this is not the same situation. It is, people are not close to this.
Agreed.
Yeah. So what is the board thinking? Commissioner, did you want to say something?
Yes, I support having language that's similar to Park City Wind to the extent that it's, the structure of the language, but I do think we want to establish a baseline. I want to be responsive to the comments that we heard today. So I think it's important to require a baseline prior to construction completion, 90 days from when the facility is fully developed, and again at 1 year. So
I think we should do that.
Yeah.
Do you have some language?
I do have language, but it does not match the Park City Wind.
That's okay. I think we should stick with what we have here and just modify what we have here.
Okay, so then my proposed language is the siting board directs the company to conduct testing of magnetic fields from the offshore export cables, the onshore cables and grid interconnection, and the converter station, which shall be done prior to construction commencement to establish a baseline 90 days from the OGF being fully developed and capable of delivering approximately 1,200 megawatts of energy, and 1 year from the OGF being fully developed. Results of the testing shall be filed with the siting board.
So is the purpose of measuring offshore about the fish?
Yes, it's marine organisms.
But it also includes, excuse me, it also includes the converter station. So that is
Yeah,
online
so that's-
and the onshore cables also onshore
I see.
and your people.
I see. Okay. Any comments on Commissioner Rubin's proposed language? Well, we have to do a motion. She hasn't done the motion. She was just telling you what she was going to propose.
But
Yes, go ahead.
if I may make a comment, I think one of the commenters said that they would rather it not be 1 year following, but like 90 days or something a little shorter because they're worried about exposure. So that we may want to think about the 1 year time frame. And in fact, Park City Wind was something like 100 days or something like that. So it's kind of 90 days, 100 days, something like that is, I think, sensitive to what some of the limited participants were saying.
Thank you. And
Mr. Runge.
Madam Chair, Eric Runge for the company. Kelly Smith does have something she wanted to add to this, please.
Kelly Smith for the company. Is this on?
No. Nope.
Kelly Smith for the company. Thank you. Just simply with respect to the offshore, I guess maybe I'll start onshore. We can appreciate the value of baseline monitoring onshore, particularly with the existing transmission infrastructure that is present. I think for efficiency, an additional vessel mobilization wouldn't add as much value offshore where there are no lines in place. And similarly, if you would want to look at the worst case impacts, waiting until full load would also make more sense offshore rather than the baseline 90-day and full load. Perhaps we could simplify the offshore condition.
That actually makes sense to me. Makes it a little bit more complicated to write, but I think that makes more sense. Okay. Want to try again?
here we go. Love editing live.
Yeah.
Okay, I'm going to make a motion. Bear with me, everyone. So I move to amend condition L to state the siting board directs the company to conduct testing of magnetic fields from the onshore cables and grid interconnection and the converter station, which shall be done prior to construction commencement to establish a baseline, 90 days from the OGF being fully developed and capable of delivering 1,200 megawatts of energy, and 1 year from the OGF being fully developed and capable of delivering approximately 1,200 megawatts of energy. The siting board directs the company to conduct testing of magnetic fields from the offshore export cables within 1 year of the project being fully installed and operational. Results of the testing shall be filed with the siting board.
Have a second?
Second.
Okay, can we have a roll call vote, please?
Chair Van Nostrand.
Yes.
Commissioner Rubin.
Yes.
Commissioner Heipel.
Yes.
General Counsel Costco.
Yes.
Deputy Counsel Dobbs.
Yes.
Mr. Bonfilio.
Yes.
Mr. Watson.
Yes.
And Secretary Tepper.
Yes.
Motion carries.
Okay, let's move on to, does any board member want to discuss potential modifications to the construction hours? I mean, I guess I would say in general, the construction hours that are currently a part of the decision do appear to be standard construction hours for big construction projects like this. That being said, I did hear the commenters, concern that, 7 o'clock at night is, not 5:30 at night. So I'm wondering if anybody has any thoughts on that.
Well, I can just say that from most of the projects that the board has approved in the past, 5:30 as an end time for weekday construction would be on the early side. And, I'm sympathetic to the concerns that have been expressed. But I do think that would, again, deviate from our past practices, and the town's noise bylaw itself allows actually much more extensive construction hours than the company has actually requested. And we have pared back what the company is seeking by saying no work on state and federal holidays, no work on Sundays. So there are limitations, and I think we're pretty much where we usually find ourselves for construction hours.
And I guess I would just add that when you shorten the construction hours, it just makes the project longer. So, it's a trade-off. Okay, so it sounds like the board's general view is to keep the condition that's in the staff's amendments as is. Let's move on to noise during operation. Did anybody want to have any thoughts on the condition with respect to noise? Not hearing none, we will move on. Okay, so are there does any board member have any other condition or issue that they would like to discuss?
Yes, Chair, I thought if we could focus on this, will be hired locally, what's being offered as condition T. I wondered if the company had any response, given what we've heard as a concern from the hearing in terms of, we did have 75% of operations and maintenance jobs with local residents. That's being replaced with will be hired locally. That doesn't seem to be an acceptable solution. Now, if we try to understand, is there a different way we can state this that could address the concerns expressed by the public?
Becky Ullman for the company. Thank you for the question. South Coast Wind supports the language as amended. We think the language reflects our commitment to the South Coast region, as well as the interconnected nature of our grid. In addition, it reflects our commitment to the building trades, to being aligned and collaborative with them as well.
But what is your concern with the way it was before saying local residents? Like what do you view as the difference between saying local residents and will be hired locally?
I believe local residents is more limited than hiring locally. Hiring locally gives us the ability to focus on the South Coast and the folks who live there without being tied to the word resident.
Can you explain how people who are tied to an area but are not a resident, what's the distinction there?
I would suggest that if the language were to remain resident, we would be having to check addresses rather than hiring from the full workforce of the South Coast.
If you're not checking addresses, how can you determine if you are hiring locally?
Because there's sort of a natural filter there. Folks who are able to commute to the workplace and sustain themselves in general are identified as local.
So like if you had a job fair and, people came and, from other places looking for a job and then, potentially moved to the area or not residents maybe at the time in which, they're looking for the job. I don't know. I mean, to me, doesn't seem like it's that big of a distinction.
I might add, if we think about it from a compliance perspective, we would then need to come up with a definition of resident, and that seems like a difficult thing to get to, whereas local reflects our commitment to working with all of the South Coast.
May I just add something to the conversation? You discussed earlier that you have a MOA with a intention to have a project labor agreement Is that project labor agreement with the Southeastern Building Trades, Southeastern Mass Building Trades? Which I believe it is?
In Rhode Island, yes.
Yes, and most of those Southeastern Mass Building Trades is an umbrella organization that has many local unions that are domiciled in Southeastern Mass, in which the preponderance of their members actually live in Southeastern Mass. Is that accurate? Okay. I thought
Thank
so.
you for adding that. Our commitment to working with organized labor, we've heard from them that addressing the whole South Coast and allowing them to organize as they see fit is beneficial.
Okay, thank you.
So what's your view on how we should do the language?
I would suggest you leave it as is.
Mr. Bonfiglio, can I just ask, as is meaning how the tentative decision was originally issued, or with the modification that was in the staff amendment sheet, there was a difference?
Staff amendment. Where did you leave off? I want to just recite what the last staff amendment was, Andrew.
The last staff amendment refers to will be hired locally.
I'm not sure I really get the distinction. I mean, it's a difference without necessarily a clear distinction in my opinion.
Can I say, I thought that there was sort of a legal and semantic and technical sort of issue there. Hired locally, from what I understood, the conversation meant that someone could come to the local location and be hired, but it didn't necessarily mean that they were a local resident. So I mean, there's a certain amount of trust that I think has to be sort of exercised here. But I thought there was a nuance there that said there was a loophole that could allow someone to come to the place, be hired, and they would be hired locally, but didn't guarantee that they were local or residents. That was my sense.
How about some reference to hired from within the South Coast community?
This is Becky Ullman for South Coast. We would be supportive of that. We could also refer to the building trades as identified by.
Well, I don't think everyone is necessarily going to be in the building trades. So I don't think you want to limit yourself to that. And you don't know what your project labor agreement is going to say yet. So, Mr. Chair, would you like to make a motion?
Yes, I move we modify condition T. I'm just trying to figure out where we have this on the amendments chart. Condition T, so that it reads, irrelevant portion, the company's progress towards fulfilling its commitment that at least 75% of operations and maintenance jobs will be hired from within the South Coast community. And the extent to which the project, and it just continues on, semicolon, and the extent to which the project's employees and subcontractors reside. And the extent to which the project's employees and subcontractors reside within an EJ population relevant to the project area.
Do I have a second?
Second.
Okay, can we have a roll call vote, please?
Chair Van Nostrand.
Yes.
Commissioner Rubin.
Yes.
Commissioner Heipel.
Yes.
General Counsel Costco.
Yes.
Deputy Counsel Dobbs.
Yes.
Mr. Bonfiglio.
Yes.
Mr. Watson.
Yes.
Secretary Tepper.
Yes.
Motion carries.
All right. Are there other issues on the conditions that anyone would like to discuss? Commissioner.
Thank you. On condition F, this relates to the emergency response plan that we discussed earlier. I move to add in the second sentence of condition F that begins at a minimum. In sub 2, the condition reads now, names and telephone numbers of local, state, and federal agencies / officials to be contacted in the event of, I propose adding an emergency, comma, including a spill of oil or hazardous materials, and keeping the rest of the condition the same. I also propose adding to the final sentence of condition F, there is a current provision that the final plan shall be submitted to the siting board 30 days prior to operation. I propose adding and regularly updated thereafter.
Do you want to have any time period on the regularly?
Annually updated thereafter. And that really is not, just to be clear, to create extra work for the company. That is in keeping with, as we discussed earlier, just the change of personnel on all sides within the company, your contractors, the officials to be contacted.
Mr. Runge.
Eric Runge for the company. May I ask if that updating includes a filing with the siting board, or is it just internal?
I think it can be kept internal. Perhaps we should say at least annually thereafter, so that if there are changes of which you're aware, you are making those as we go. But I do think having clarity internally within the company and your contractors and partners is important.
Thank you.
What happens during construction? It says the final ERP shall be submitted 30 days prior to operation.
Would it be problematic for the company to change that to prior to construction? Are you able to finalize that plan before construction?
Yes, sorry, Becky Ullman for the company. The answer is yes. I think that's a best practice that we've learned over the past few months, and we'd be happy to commit to that.
And I could see that the emergency response plan would evolve between the time that you're doing it for construction and the time that you do it for operation, but you would have some kind of plan in place during the construction period.
Yes, this is Kelly Smith for the company. We typically consider that umbrellaed under the construction management plan. So I think that's sort of how we would look at the breakout and phasing.
Maybe as part of your construction management plan, you could have a section that would be specifically about these kinds of issues.
Yes.
Okay. Okay. Do you want to modify, or are you good? You changed the end of it so that it would be 30 days prior to construction.
Yes, the final sentence would read, the final ERP shall be submitted to the siting board 30 days prior to construction and updated at least annually thereafter.
Is there a second?
Second.
Can I have a roll call vote, please?
Chair Van Nostrand,
Yes.
Commissioner Rubin,
Yes.
Commissioner Heipel,
Yes.
General Counsel Costco,
Yes.
Deputy Counsel Dobbs.
Yes.
Mr. Bonfilio,
Yes.
Mr. Watson,
Yes.
Secretary Tepper.
Yes.
Motion carries.
Okay, any other issues with respect to the conditions? All right, are there any issues that we want to discuss with respect to the order itself?
I would just ask, and I know the staff always does this anyway, but in areas in which a condition repeats language in the decision itself, that we've modified the condition, I know you go back, but just to say it on the record that staff will go back and make a corresponding change to the language in the condition or in the decision itself.
Staff will make sure that the language is consistent. Thank you.
We appreciate that very much. Thank you.
Okay, so we have a motion on the floor for the staff amendments. So I think we now need a motion for the staff amendments as modified as we have talked about today, that we have already voted on, and approve them as a whole.
So I move to accept the staff amendments that do not address the conditions we've already modified.
Second.
Thank you. Can we have a roll call vote?
Chair Van Nostrand.
Yes.
Commissioner Rubin.
Yes.
Commissioner Heipel.
Yes.
General Counsel Costco.
Yes.
Deputy Counsel Dobbs.
Yes.
Mr. Bonfiglio. Mr. Watson.
Yes.
Secretary Tepper.
Yes.
Motion carries.
All right. Is there anything else that the board would like to raise this afternoon? I would just like to say thank you to everybody. This has been a very helpful hearing. I think we made some good modifications. Again, also would like to thank the staff for all the work on this case. Some of us actually read the whole thing, and it's very well written. It's well written and well argued. So thank you for laying out all the issues. Yes. I know we haven't got there yet. Yes. So thank you. And thank you to the members of the public who participated, the limited participants who participated today. As you can tell, your comments were very helpful in us thinking about further about the conditions. So thank you for your time and your input. All right, so we have a motion on the table for adopting the tentative decision as amended. Can we have a roll call vote, please?
Sure. Chair Van Nostrand.
Yes.
Commissioner Rubin.
Yes.
Commissioner Heipel.
Yes.
General Counsel Costco.
Yes.
Deputy Counsel Dobbs.
Yes.
Mr. Bonfiglio. Mr. Watson.
Yes.
Chair Tepper.
Yes.
Motion carries.
Thank you all very much. Good afternoon. We're off the record.